Yields back, Ms. Garcia.
Thank you, Mr. Chairman, and thank you for bringing us together for this very important, very critical hearing. And I want to thank all the witnesses for being here today. Justice Thomas has de facto given the green light for the conservative-controlled states in our nation to continue a crusade against the liberties and freedoms of every individual that is not male, white, and straight. They started with women, throwing us back to the dark ages, treating us as property and cattle, forcing us to give birth against our will, treating us as subjects and handmaids at the service of the government. Next, it will go against gays, lesbians, transgender individuals, and the LGBTQ community. In Texas, Republican Attorney General has already expressed in no uncertain terms that he has a full intention of litigating in favor of overturning Lawrence v. Texas. Now, this case started in my district. Back then, it was in 1988, the arrest of Mr. Lawrence was at a resident of what is now my district, and it was all about keeping the government's reach outside of people's bedrooms and their intimate lives where it should stay. It's regrettable that our Attorney General is already thinking about doing something about that. Republicans who claim to believe in small government, in their never-ending hypocrisy, are weaponizing the state to criminalize the most intimate aspects of our lives. What happens between two consenting adults in the privacy of their homes is no one's business. Religion is not a basis for public policy. I am a Catholic, but we must keep our rosaries for prayer and not to restrain from their liberties. I thank the witnesses for coming, and I want to start with you, Professor Murray. Is it extreme that anti-abortion activists have been responsible for at least 11 murders, 26 attempted murders, 42 bombings, 194 arsons, and thousands of incidents of criminal activities directed at abortion providers since 1977?
It is extreme. I find it really interesting that the Republicans in this hearing have emphasized the protests against the Supreme Court justices and individuals exercising their First Amendment rights in a peaceful manner, when in fact we have since 1977 a long history of actual violence against those who provide abortions and those who seek abortion care. I will also note that in 2014, the Supreme Court of the United States in McCullen versus Coakley invalidated a law that the people of Massachusetts enacted through their legislature to provide a 35-foot buffer zone between abortion clinics and protesters so that individuals could enter those clinics in a peaceful manner to make decisions about their health care. The Supreme Court invalidated that, subjecting those individuals to the protests and disagreements, and in often many cases, the intimidation of those who oppose abortion.
So that's part of the hypocrisy. They don't want a buffer zone at abortion providers' centers, but they want some type of buffer zone around their homes when they're eating. I mean, should we just make them a little bubble boys and girls so they can just go and be protected in a bubble?
I mean, the court emphasized that the protesters at abortion clinics were exercising their First Amendment rights in a peaceful manner. I do not condone violence in any way, but I agree with the court that those who wish to exercise their First Amendment rights peacefully should be able to do so.
Well, I agree with you. I don't condone any violence, and I, in fact, am a former judge, and I, in fact, have had death threats. But I just feel that I've always had law enforcement. I've always had people who can protect you, and people have a right to protest. They have a right to be there, particularly if they're staying in public sidewalks. So thank you for that. And do you think that there's anything that would, I keep hearing this whole notion of it needs to go back to the elected representatives. Well, last time I checked, I was an elected representative.
That is exactly right, Representative Garcia. I want to correct Representative McClintock's statement that this does not augur the prospect of a federal ban on abortion. Justice Kavanaugh, on pages 2 and 3 of his concurring opinion in Dobbs, makes clear that this simply returns this issue to the prospect of democratic deliberation in the states and Congress. Those are the words of this opinion. This will surely come to Congress if there is a Republican majority.
Thank you for that. And Mr. Chairman, I want to, for the record, introduce the National Abortion Federation Center's report dated May 19, 2022, listing all the violence against abortion providers since 1977.
Without objection,
Thank you.
the gentlelady's time has expired.